Good morning, everyone, again. First of all, I would like to say that we are really sorry for the delay due to a technical problem. Today in this session, in this panel, we will discuss about alternative forms of regulations. And before that, I would like to thank, first of all, Professor Jose Maria Miranda Boto and Professor Elizabeth Brown-Huber for their excellent leadership through the project process, and also the University of Santiago de Compostela and the technical team, which enabled us to reach you in this conference. So, as Elizabeth mentioned, that even though if there exist some problems regarding collective bargaining, collective agreements in stricto sensu, alternative forms of regulation may prevent efficient protections to the platform workers. Charters and code of conduct could provide protection to platform workers to some extent. So in this panel session, we will discuss what kind of alternative forms of regulations. Today, I would like to first of all welcome Professor Judith Bochmann. She's a professor for health politics and law at Hamburg University of Applied Sciences, and she does research in German and European labor law. Judith will talk about the code of conduct in Germany, and then Professor Luca Ratti, and hopefully he will join us during this process. So the floor is yours, Judith.
Okay, thank you very much, Kübra. Thank you very much, colleagues, to have organized, and thank you very much to join us today, colleagues from within our project group and from all over Europe or the world. Thanks also to the technical assistance, and it would be great if we could share the slides. If it's not possible yet, I'll start my presentation. That's perfect, thank you very much. So what I would like to present and then discuss with you is a possible or an existing alternative to collective bargaining that needs to be analyzed from a legal point of view, which is the Code of Conduct Paid Crowd Work for the Better, as it's called. Next slide, please. And before presenting what the Code of Conduct is and what its content is, how it works, how it is applied, and then analyzing it in depth from a legal point of view, I need to quickly expose the general field or the development of this Code of Conduct before. So what was happening with the emergence of crowd work and platform work was also, and we all know that, a challenging situation for trade unions. And what was happening a little bit behind the scenes is that trade unions, not only in Germany, but all over Europe and even all over the world, the phenomenon is global, had to develop new strategies, and that happens within a collaboration process between different trade unions from different countries who issued or who developed the so-called Frankfurt Declaration in 2016. So next slide, please. Actually, different trade unions, you can see from Austria, from Denmark, also the German Metal Workers Union, IG Metall, but also US-American trade unions and union from Sweden, gathered and collaborated a proposal for platform operators, clients, policymakers, workers, and worker organizations in 2016. This is the so-called Frankfurt Declaration. And what is interesting to see, next slide please, that we have here this proposal, and I'd like to read that to you because you can see a shift in trade union strategy, which is to propose, therefore, that the growth of platform-based work presents a novel opportunity for the development of a cooperative turn in labor management relations. The traditional conflictual processes of labor management relations have secured crucial rights for workers over the years and will continue to be important. But insofar as platform operators understand that their own long-term well-being and that of society at large is bound up with the ability of workers, regardless of legal status, to secure good work, future labor management interactions may be organized around interests deeply shared by all parties. This possibility offers the hope of great gains for all parties. So this is trade union strategy, and we see the declaration is talking about a shift to cooperative labor management relations, so less conflictual, more cooperative, to open up that sector, which is the platform economy or the crowdsourcing economy. So we can ask ourselves whether this cooperative turn is a sort of a reasonable accommodation in trade union strategies for a new era. Could that be an alternative to traditional labor action and collective bargaining? Let's see. We go to the next slide, please. Just to resume or to explain somehow how we can understand that shift in strategy, maybe, let me just repeat what you all know, that work in the crowd economy or in the platform economy is performed individually rather than in teams. Of course, that exists also, but it's not a teamwork at a common working place. And of course, the crowd can be global or more regional, more restrained, but it's not in one place. So obviously, there is little to no coherence as a collective. It's much more difficult to organize workers, to unionize workers, and it's difficult to reach them by the traditional ways of trade union action or strategy. So this is something that have to be borne in mind when we understand this code of conduct. Because that means, next slide please, that there are important challenges for the traditional collective action, because it's not only difficult on the factual side, but also on the legal side of things. The transnational situation makes it more difficult to determine the applicable law because it's transnational, and we already see that in traditional employment relation, this can cause problems. Then lots of systems ask for representativeness of trade unions when it comes to collective bargaining. This is an unsolved problem. And as Elisabeth Brammes-Huber underlined in her presentation, the status most problems because collective bargaining is possible until today for workers in an classical employment relationship, not for dependent workers or that sort of categories like WEDL, the economically dependent workers Elisabeth Brammes-Huber was talking about earlier. So please go to the next slide. That is why trade unions, together with platforms, thought about new ways to collaborate. And that's how the code of conduct came into life. Just to very briefly give you an impression what happened. There was a platform, a German platform called testbirds, that issued a first version of a code of conduct as only for that company, only for that platform in 2015. Then came the Frankfurt Declaration in 2016, and in 2017, the German IG Metall started to collaborate with testbirds, the Deutscher Crowdsourcing-Verband, which is the sector business association of platforms, came to support this collaboration. And there were more platforms interested in issuing or developing a code of conduct. That's why in the beginning of 2017, they signed, please go back again. Very briefly, yeah, thank you. So they issued a revised version of the Code of Conduct, which went together with the appointment of an ombuds office, how it's called in the official translation, or an ombudsman's office in the end of 2017. So this Code of Conduct is a voluntary declaration by today 9 platforms. Next slide, please. I won't read you out loud what you can read here yourself. These are the actual 9 signatory platforms of the Code of Conduct. And what you can see is that you have all sorts of platforms, which means there are micro-tasking platforms, highly specialized creative tasks, retail intelligence. It is terrestrial work on demand, and also pure virtual crowd work, with either local or global execution. And you can see also that there are business activities on different levels. It might be national. Most of the platforms are Germany-based, except 𝐂𝐺𝐒, but also globally operating platforms. And you can see that these are platforms of all sizes, going from 6,000 registered platform workers to over 1 million. So it's really all sorts. In the beginning, there were 8. One of the signatories resigned from the Code of Conduct, and 2 others joined, so there's still a little dynamic. Please go to the next slide. So when it comes to the objective and the purpose, as I said, it's voluntary, self-imposed guidelines for, as they say, prominent crowdsourcing companies that are developed and improved constantly. And the important thing, of course, is that only members will apply these guidelines, and they have no validity outside the circle of members. So they are not enforceable before the courts. Please go to the next slide. The content, when it comes to the content, the material content, the Code of Conduct sets up 10 principles that concern the areas that I put on the slide for you. I'd like to draw your attention for now to the number 9, the regulated approval process and rework, because the Code of Conduct says that in case that there are differences between the platform and the platform workers, there is the possibility to make appeal to an ombuds office. Please go to the next slide. And this is something that is interesting because it is a voluntary instrument, but it also cares for or provides a possibility to privately enforce, not before the courts, but before that ombuds office, the rights or the principles, the breach of principles as foreseen by the Code of Conduct. The interesting thing is that there are procedural rules. This is not something that is astonishing, but the administration of the Ombuds Office is operated by the German trade union IG Metall. It is very easy to file a complaint because there is an internet form that exists. It's available in German and in English, even though most of the procedures or most of the complaints were filed in German. Please go to the next slide. The Ombuds Office itself is appointed by the signatories, and there are 5 members, as you can see. There is also a representative of the German Confederation of Trade Unions, Deutscher Gewerkschaftsbund, the DGB, which is since 2017 a member of the IG Metall, but it could be any other trade union. And I would like to draw your attention to one particularity that seems important to me when it comes to that cross-border or transnational situation, because the rules allow for involving a trade union representative from the country where the platform worker is based in an advisory capacity. So this is really important from my point of view, because this is something special and it's a real added value, if I can say, in that situation. Please go to the next slide. So this was a very brief presentation of what the Code of Conduct is in terms of its content, but also the procedural side. So if we come to a legal analysis, and if we ask ourselves whether this could be an alternative instrument compared to collective bargaining, we can clearly say that it is a way, or we have to admit that there are at least some minimum standards, which are standards in the sector, and that, as we could see, it is also an instrument that may be quite good in dealing with the transnational situations. It is applicable independent of the legal status of the platform workers, so all the problems, legal problems that arise from different legal statuses that are outside the classical employment relationship do not hinder the application of the Code of Conduct. With that special, the creation of that special Ombuds Office, we have a new possibility to access to rights, to enforce rights, and it's a very easy procedure with less language obstacles than to file complaints before a national court. And of course, it's also an instrument to do benchmarking in the sector for the platforms. But this is, I mean, there's not only that side of the moon, but also the dark side. So let's go to the next and last slide, please. Because obviously there are limitations to the instruments and deficiencies if we compare it to classical collective bargaining agreements. It is a voluntary instrument. So the minimum standards are by far no guarantees. It's no rights. It is more a framework agreement, of course. And even though it might facilitate the access to rights in a situation where there are no others, it's not comparable to enforceable subjective rights for workers or platform workers. Finally, we can see all the inconveniences that those voluntary agreements have, and it has been discussed for a long time with all the CSR guidelines, for example, in delivery chains. I mean, you know that it doesn't really regulate the market. it's for the good ones, let's say. So those who are ready to comply with that kind of rules can do it, and for them that might be an advantage on the market, but it can by far not guarantee rights to platform workers. So it is an achievement on the way to more collective labor rights in that sector of platform work or crowd work, from my point of view, but it's by far not an alternative instrument. So the way doesn't end here, but we'll have to go on, and the social partners, the different actors, will have to go on by developing more appropriate and more protective collective instruments in that sector of platform work and crowd work. So please go to the next slide. Thank you very much. I know that that was a brief presentation, and I hope that we'll have a lively discussion.
Thank you very much, Judith. It was a really thought-provoking presentation, and we can see the innovative part of labor law. And I would like to welcome Professor Luca Ratti. I know he has been tackling with technical problems for 30 minutes. Welcome, Luca. He's from University of Luxembourg, and he's a professor of European and comparative labor law. Since February 2020, he coordinates the Horizon 2020 project, which is called Working at Poor. And since we know the EU Commission work program, a legislative initiative on improving the working conditions of platform workers by the end of this year, I believe it's very timely to talk about crowd work and work on demand in the European legal framework. Luca, the floor is yours. Okay, maybe it's better if I ask a question to benefit the time also a little bit more to Judith. Judith told us that an alternative form of regulation is code of conduct, and I find it quite interesting to see that alternative forms of regulations comes with their alternative dispute resolution mechanisms. And Judith told us about Ombudsman Office. Could you elaborate a bit further on this issue, Judith? It's an interesting innovation in maybe labor law.
I mean, to me, that it is quite near to the model that we know on the workers' participation on level. So I see that the image is really bad. I hope that the connection is better and that you can hear me. So the interesting thing is that we know from workers' participation on planned level under the German Works Constitution Act that there are these kind of mechanisms. But as you say, this is a voluntary alternative dispute resolution instrument. And what I find striking is that, of course, the code of conduct is unilateral. It is signed on platform side. Of course, it is no agreement between the trade union on the one hand, or workers' representatives on the one hand, and the platforms on the other hand, but it is unilaterally signed by the platforms. However, it has been elaborated in collaboration with the German trade union IG Metall, and the trade union is also involved in the Ombuds Office, not only as the administrative secretary, but also, and importantly, they send a representative along with a workers' representative who does not have to be member of a trade union, of course. So this seems important to me, and there are also some statistics. I think I can show you the slide I prepared for that, but there are about, or there have been in 2018 and 2019, between 15 to 30 cases that have been dealt with by the Ombuds Office. So if we compare it to the number of platform workers who subscribe to these platforms and to work for these platforms, this is only a very small percentages, as we can suppose. But I think what is important to underline is to open that possibility for platform workers to make appeal to a third person or an ombuds person, and to have dispute resolutions mechanisms outside the contractual relationship between the platform and the crowd worker. Thank you.
Thank you very much, Judith. I'm afraid Luca has some still problems, and we couldn't solve really this problem, technical problem. So I'm sorry to say that he couldn't join us today. So maybe if we have still some patient audience, I would like to give the floor to our audience. You may ask your questions by just raising your hands or just write it in the chat box of Zoom. So we will be, I will be happy to address your questions to Judith. Any question? I can't. Okay, for the moment, I'm sorry. I can't see the questions now. Okay. I can Yes. Can you help me a little bit? I can't see if there's any raised hand. At least I can't see it. Okay. For the moment, I'm afraid there's no question. We are all really sorry about this technical problem. Judith, would you like to add something?
I mean, I very quickly, or I didn't develop much on the content, like the principles. And maybe we can insist a little bit because, as I said, there were no material rights. And if we have a look to that list, it seems really that these are more, as I said, it's only a framework, and these are very basic questions. So when it comes to fair payment, I think that there are important points stressed, like the clarification of payment conditions, time limits, and payouts cycles that should be transparent, and the payout should be ensured at least once a month. So I think this is quite important. But of course, there is no minimum wage. So if we look at these principles, they are very basic framework principles, which also means that they are quite easy to respect, and they do not guarantee a minimum standards or minimum guarantees. However, what seems important to me is the question of clear tasks and reasonable timing, because this might be a problem, and also the fact that they call the principle freedom and flexibility, that the flexibility of platform workers should be respected, which means that the fact that the platform worker refuses an offered task may not lead to any inconveniences. So, which is important if we think about ratings, for example. Also, non-discrimination is an important principle, but it is not developed further. So there are no standards introduced how to prevent discrimination. Finally, there is also a principle about data protection and privacy, and if we read it, it comes very, very general. Of course, respect for and protection of the crowd workers' privacy is paramount, but then there is no information about the algorithms, for example, which are nowadays discussed as one of the main issues in connection with data protection of the workers. So this maybe briefly, I see in the session's internal chat that there might be questions. So I don't know if it's possible.
Now we have one question, hopefully, in Nicola Gund. Thank you, Nicola. She asked that, in your view, the decisions of the ombudsperson get some legal value by means of an agreement between the parties. So, for example, if employers agree to stick to any of their rulings.
That's very interesting. Thank you, Nicola, for the question. In fact, that we have a very basic statistic in a report that is issued every year, every 2 years, by the Ombuds Office, and that you can, I had it on my slides, so you can, it's accessible online. And from that, we can see that in most of the cases, there was mediation. So by discussing the matters with the members of the Ombuds Office, the parties found an agreement, even not with a means of a formal settlement, but there also have been few cases with formal settlements signed by the platform worker and the platform. And finally, there were 2 formal decisions issued. Of course, we don't know because there is no official follow-up whether they have been accepted and also applied by the platform. And what I can add maybe is that we were talking about individual disputes between the platforms and the platform workers. However, the Ombuds Office is also competent to actually to decide on the breach of the code of conduct. So if there are complaints that the code of conduct is not applied by the platform, this might also be an issue before the Ombuds Office. And as I said earlier, there's one platform that resigned from the code of conduct, and it is interesting because I have no information on whether that matter had been discussed by the Ombuds Office before. But what I can say is that from what is public information that is publicly accessible, that there were lots of complaints about the non-application of the code of conduct in forums of platform workers. So that is something I can trace, but I don't know whether that has been an issue, because this is one of the, of course, internal procedures that hasn't been rendered public.
Thank you very much. And we have another question from Hazal Yılmaz. She's a doctorate student in Turkey. She also thanks for your presentation, and she has 2 questions. First of all, does the Ombuds Office have a disciplinary power over the platforms, a kind of power? And secondly, is there a provision on right to data portability protection in Frankfurt Declaration?
Thank you very much. So concerning the first question, there is no formal disciplinary power of the Ombuds Office over the platforms. However, the rules declare the Ombuds Office competent to decide on breaches of or complaints concerning not individual cases, but the overall application of the code of conduct. And of course, it's the members, or they call themselves members, the signatories of the code of conduct, who may also exclude one of the members. So even if it's no formal power to exclude that member given to the Ombuds Office, a discussion or even a decision of the Ombuds Office would and could lead to an exclusion by the other signatories. First question. And the second question is concerning data portability. No, in the code of conduct, that's what I said, is like the right or the right to access to information about the algorithms. I think these are 2 of the important points that we discussed today when it comes to data protection and the rights of platform workers. And here it's a clearly no. It is not provided in principle number 10, which is on data protection and privacy of that code of conduct, fair crowd work for the better, and which is not included in the Frankfurt Declaration. The Frankfurt Declaration was that joint statement by different trade unions, actually issued in 2016, before the principles were established by the platforms in collaboration with IG Metall.
Thank you very much. And we have hopefully some further questions. Nicola elaborates on her question, and she asks that could you incorporate the code of conduct into contracts between users and platform workers? Non-compliance, so therefore non-compliance could be a contract law issue and be sanctioned like that. What do you think on this issue, please?
I think this is possible because we can always argue that when a platform signs that code of conduct and commits itself to respect the rules in that, and also renders this public, which is the case, of course, in the contractual relationship, the platform workers may invoke a breach of the principles of the code of conduct. However, the principles are very general rules, so it's a long way to starting from the contract. And I think, at least in German contractual law, it would be a question of the execution of the contract in good faith, also to apply the principles. But to come to a concrete breach of contract, because it would be the platform work, the responsibility of the platform worker to establish that there was breach of contract because the very concrete behavior of the platform does not respect the principles. So it's a long way of interpretation of the contract. And of course, this has to be brought before the courts. And then we have that access to rights problem again, because we may have issues with a competent jurisdiction, whether that was labor jurisdiction on the one hand or the civil courts for self-employed.
Thank you very much. I think it's not surprising that a majority of audience is lawyers, so everybody's thinking about the enforceability issues. So there's another question from Albert Albanese. He wrote that, as mentioned, for now, there is a limited number of members that are signatories of this code of conduct. Hence, the guidelines do not apply to non-signatory parties. However, as far as signatory parties are concerned, can the guidelines in this code be considered enforceable? Thank you.
I think this goes in the same direction as Nicola's question before. I think as such, there is the principles don't give, or the code of conduct does not give any legal basis, but it would be via the contract and the question of an eventual breach of contract via the execution in good faith. I don't see that the code of conduct itself as a voluntary and unilaterally signed declaration of the employer in itself could be a legal basis to invoke rights. And as I said, it stays so general that we would need an incriminated behavior to say that this behavior was against the principles, and the fact that the platform acted against the principles would constitute or would contravene the execution in good faith of a contract.
Thank you very much. And Nicola is elaborating further, and but work councils could make these general rules more concrete rights. So work councils could be helpful in the execution of these rules. What do you think on the issue?
That's a very interesting question. Thank you very much, because it links workers' representation in the business on the platform to the code of conduct. And here I have to say that, at least in German labor law, works councils are only competent and representing the interests of employees. So when we're talking about employment relationships and the application of the code of conduct in employment relationships, we might discuss that question. However, and now I talk as a German lawyer, the code of conduct has no collective dimension in the business or in the enterprise, but it has on the very abstract level that collective aspect that the German trade union IG Metall was involved and did counseling in the conceptualization of the code of conduct. However, it doesn't create that collective situation within the enterprise or the plant level. So that I don't think that that this would work under the German legislation. However, that might, or that could be appreciated completely different if the code of conduct was applied, for example, under British law, because there's also one of the platforms that is UK based. Thank you.
Thank you very much for all these questions. And thank you, Judith, for this thought-provoking presentation. It gives us an opportunity to think beyond our legal forms and categories. So it was very helpful to think on the issue and to think about what we can do for the protection, for more efficient protection until the legislative intervention at least. Thank you to all the audience, in fact. As far as I see, there's no more question. And I would like to express that we are really sorry for the technical problems, and we are really sorry that we couldn't listen to Professor Luca Ratti. But I hope we will have chance to read his report or his article in the future as a part of the project publication. If there's no other question, I would like to thank all the audience and close this session up. Thank you very much. Thank you very much, Judith. See you in the next panel. Bye.